June 13, 1966. Today, the Supreme Court handed down a decision that guarantees criminal defendants will be made aware of their constitutional rights. Some are calling Miranda v. Arizona a landmark decision. Others say it is a victory for criminals.
Yeah, I did it. I didn't want to, but she made me do it. Always nagging me.
The Fifth Amendment to the U.S. Constitution states that no person shall be compelled in any criminal case to be a witness against himself. But what does that really mean? Inside this building, 9 men have deliberated over one of the most controversial criminal law cases of our time, Miranda v. Arizona. It began when a man named Ernesto Miranda signed a confession during police questioning. Did he have a right to have a lawyer present? Did police need to tell him that he could remain silent if he chose? The justices have heard arguments representing both sides of the case. John J. Flynn, the attorney representing defendant Ernesto Miranda, argued,
"Under the facts and circumstances in Miranda of a man of limited education, of a man who certainly is mentally abnormal, who is certainly an indigent, when the adversary process came into being, the police, at the very least, had an obligation to extend to this man not only his clear Fifth Amendment right, but to accord to him the right of counsel."
Gary K. Nelson argued on behalf of the state of Arizona.
If the extreme position is adopted that says he has to either have counsel at this stage or intelligently waive counsel, then a serious problem in the enforcement of our criminal law will occur.
By a narrow margin of 5-4, the Supreme Court has decided in favor of Miranda. Chief Justice Earl Warren expressed the majority opinion. Quote, "When an individual is taken into custody or otherwise deprived of his freedom by the authorities in any significant way, and is subjected to questioning, the privilege against self-incrimination is jeopardized." End quote. Justice Harlan strongly disagreed, but his was the minority position. Quote, "The social costs of crime are too great to call the new rules anything but a hazardous experimentation." End quote. The controversy over Miranda has continued outside the courtroom. Does the court's ruling coddle criminals or protect individuals from police intimidation? In a Senate hearing about controlling crime, Senator Sam J. Ervin declared,
As a practical matter, isn't the result of the Miranda decision that self-confessed criminals are turned free in the courts throughout this country simply because the arresting officer failed to tell the criminals something he already knew?
Others, such as Senator Robert Kennedy, felt differently. Quote, "You think that additional warning in some way infringes upon effective law enforcement? Those are his rights, are they not, under the Constitution? Doesn't he have the right to remain silent? Did you tell him he could have the opportunity to keep his mouth shut?" End quote. The ruling has made crime and law enforcement an issue in the 1968 presidential campaign.
In recent years, crime in this country has grown 9 times as fast as population. I pledge to you, the wave of crime is not going to be the wave of the future in America.
There's no doubt Miranda will remain a contentious decision. But for now, police will need to add a few more lines to their rule book.
You have the right to remain silent and refuse to answer any questions. Anything you say may be used against you in a court of law. You have the right to consult with an attorney at any time and have him present before and during questioning. If you cannot afford an attorney, one will be provided if you so desire prior to questioning.